Okay. Good afternoon, Mr. Grant, and welcome to our presentation. My name is Julia Sachenko, and today, together with my teammates Alexis Moller and Renuka Nagra, we will present the topic about cartels, horizontal and vertical, which represents Article 101 TFEU. So I will talk about theory, then Renuka will proceed with the introducing the IREC method, and she will talk also about one of the cases. Then Alexis also will talk about one case, and I will talk about one case, and then Alexis will do the conclusion of our presentation. So Article 101 TFEU prohibits agreements between two or more independent market operators, which restrict competition. This provision covers both horizontal agreements between actual or potential competitors operating at the same level of the supply chain, and vertical agreements between firms operating at different levels. So agreements which distort competition on the European market are forbidden. Article 101 TFEU prohibits the following things. It's the agreements between undertakings, decisions by associations of undertakings, and concerted practices. Moreover, there are some prohibitions, exceptions, sorry, from Article 101 under 1 TFEU. If an agreement restricts competition, it's automatically null and void according to Article 101 under 2 TFEU. Article 101 under 3 TFEU gives dispensation to agreements mentioned in Article 101 under 1. If the conditions of Article 101 under 3 TFEU are met, first, contributes to improving the production or distribution of goods or to promoting technical or economic progress. Second, allows consumers a fair share of the resulting benefits. The third, doesn't impose on the undertakings concerned restrictions which are not indispensable to the attainment of these objectives. And last one is doesn't afford such undertakings the possibility of eliminating competition in respect of a substantial part of the products in questions. Furthermore, for taking part in a cartel, there is a punishment. Article 103 TFEU gives the Council of Ministers the power to implement an enforcement system, including the imposition of fines. Council Regulation 203, based on Article 103 TFEU, gives the Commission the power to enforce these rules and fine companies for infringements. Under a Lancet program, the first participant in the cartel to come forward receives immunity from the penalty imposed on cartel members in exchange for the voluntary disclosure of information regarding the cartel. Moreover, companies that acknowledge their involvement in the cartel get a smaller fine in return. For example, reductions can be up to 50% on the fine. And lastly, the maximum fine is 10% of the overall annual turnover of the company. Hey, Renuka, you can proceed with the presentation.
Thank you, Julia, for introducing theory. I would like to start with the IREC method. The IREC method stands for issue, rule, analysis, and conclusion. Each case in this presentation will be explained according to the IREC method. So the issue states the problem presenting the essay question. The rule describes which law applies to each case. So we have 4 cases. So there will be a lot of rules required from the book we got from. And the analysis applied the rules to the facts of the problem or question, using the facts to explain how the rules leads to the conclusion. Okay, so let's start with case 1. Commission fines regarding battery produces 166 million in cartel settlements. So the issue is right here is 3 companies, Sony, Panasonic, and Sanyo, have been fined 166 million euros by the European Union. The fine was in response to the breach of the EU antitrust law, which was related to price fixing and the change of commercially sensitive information. This to provide a restriction competition and provide a competitive advantage to the companies involved. The following charges has not been undertaken by the three firms together with the fourth company, Samsung SDI. First, they increased the price of lithium-ion batteries temporarily, and then the increase of the compensate for the rising price of cobalt, the raw materials for the batteries. Secondly, the four companies exchanged sensitive commercial information, including price, demand, and supply forecast. Let's go to the next slide. Yeah. So now we have three rules according to the issue. So the first rule is in Article 101 of the TFEU seeks to prohibit anti-competitive behavior within the EU. This can include price fixing either through explicit and implicit acts. It also regulates the sharing of market sources. The second article, 102 of the TFEU, restricts of the behavior of dominant markets participants. And lastly, is the third article, Article 23, provides the Commission with the mechanism that they can apply when determining the nature of retribution to impose on a company in breach of legislation concerning competition. So now I want to talk about the analysis of this case. Go to the next slide. Yeah. So the four companies were guilty of breaching Article 101 of the TFEU. The decision by the four companies to set the pricing of lithium-ion batteries temporarily between 2005 and 2006 is indicative of price fixing. This outcome is illustrative of anti-competitive behavior. It would disadvantage other players in the market, and the act sustained the increase in pricing lithium-ion batteries if the agreement among the four companies stand. It would affect consumer negatively. And the EU must declare the companies liable to breach of Article 101 since it would lead to consumer protection. Secondly, the article prohibits the sharing of commercially sensitive information if it's bound to affect factors. The company shared such information in manner that would influence final prices, especially concerning their pricing attention when binding customers. So Panasonic and Seo are related parties with a dominant position in the market. Their breach was also contributed to Article 102. Panasonic, Sony, and Sanyo were fined while the Samsung SDI was not. The reason of that is according to Article 23, a firm that reports antitrust behavior can have its applicable fine lifted by the Commission. On to the next slide. Yeah, the conclusion. So the four companies are liable to an Article 102 to offense because of their informal agreement to fix pricing and sharing sensitive market information. In this absence of formal contractual understanding among the four companies, their understanding is in a breach of Regents antitrust legislation. Samsung SDI may not have to pay a fine. Thank you. Going to the next. This is case 2.
Okay, yeah, this is okay. So for case 3, or sorry, case 2, Commission fines 3 companies 68 million euros for car battery recycling cartel. Recycling companies treat and recover scrap batteries and sell the recycled lead to battery manufacturers, who then use it to make new car batteries. From 2009 to 2012, 4 recycling companies, Gumpine, Ecobat Technologies, Johnson Controls, and Recyclex, cooperated in a cartel in an effort to diminish the value of scrap lead-acid automotive batteries to lower the purchase price paid to scrap dealers and collectors in Belgium, France, Germany, and the Netherlands. Was the behavior of the 4 recycling companies in violation of the TFEU? Okay, next slide. Article 101 of the TFEU. The article seeks to prohibit anti-competitive behavior in the internal market within the EU. Some of the practices that this article seeks to prevent include price fixing either through explicit or implicit acts. It also regulates the sharing of markets or sources of inputs and any activity that may restrict production or normal market forces. Article 102 of the TFEU. The article restricts the behavior of dominant market participants that leverage on the dominant position to limit production, fix prices, or distort normal market activities. Article 23A of Regulation number 1/2003. The law provides the Commission with a detailed breakdown of the guidelines it should apply when imposing fines and other forms of retributions on an entity that is found in breach of any applicable rules on competition. Additionally, it also empowers the Commission to grant immunity for organizations that report any antitrust behavior. Next one. Companies are at times guilty of behaving in ways that restrict and distort market competition. This behavior includes any activities considered within the realm of concerted parties, such as abusing a position of power, undertakings, making price agreements, or agreeing to divide markets and or points of supply. The agreement between the 4 recycling companies to lower the prices paid for scrap batteries was restricted business practice. The 4 companies disrupted the normal functioning of the market and prevented competition on price by agreeing to lower the prices paid for scrap batteries. In this case, competition between producers was prevented and restricted. Much like when most cartels collude for higher sales prices, the 4 recycling companies engage in anti-competitive behavior by conspiring to drop their purchase price paid to scrap dealers. By agreeing to lower the prices paid to scrap batteries, the 4 companies prevented, restricted, and distorted competition in the normal functioning market and prevented competition on price. The effect of the agreement or the acts of producers is clearly to restrict fair competition and was felt within the EU. This behavior of preventing and restricting competition between producers was intended to lower the value of used batteries sold for scrap and was detrimental to sellers. Next. To conclude, the agreements and behavior of the 4 recycling companies are in violation of Article 101 TFEU. Ecobat, Recyclex, and Campine are liable for fines imposed by the Commission, as well as being subject to subpoena for damages, as they may be awarded without being reduced on account of the Commission fine. For revealing the existence of the cartel, Johnson Controls receives full immunity and has avoided the fine for its participation in the infringement of Article 101A and E under Article 23(2)A of Regulation number 1/2003. Okay, done.
I'm going to check if it's recording for the safety. Yeah, okay, it's good. Okay. Case 3.
Thank you. So the last case for our presentation is the issue that was with the 5 major companies, mobile telephone operator, with the Dutch mobile phone operators in the Netherlands. It was a T-Mobile, KPN Mobile, Orange Netherlands, Vodafone, and the 5th one that I cannot really spell. So those 5 companies that held a single meeting to discuss the reduction of standard dealer remunerations for post-subscriptions. So the Court of Justice needed to decide if there was a concerted practices in this case. The next slide, please. Yeah, thank you. So the rule that it's applicable in this case is the Article 101 under 1 TFEU. So all agreements between undertakings, decisions by associations of undertakings and concert practices which may affect the trade between member states and which have as their object or effect the prevention, restriction, or disruption of competition within the internal market, and in particular those which directly or indirectly fix purchases or selling prices or any other trading conditions, limit or control production, markets, technical development or investment, share markets of sources of supply, make the conclusion of contract subject to acceptance by the other parties of supplementary obligations which by their nature or according to commercial usage have no connection with the subject of such contract shall be prohibited as incompatible with the internal market. And next slide, please. Yeah, thank you. So those 5 companies were in the breach of the Article 101 under 1 TFEU. So at the single meeting, where representative of the 5 mobile operators in the Netherlands exchanged the price information. The concerted practices pursue an anti-competitive object as referred to in Article 101 under 1 TFEU, where according to its content and objectives, it's capable in an individual case of resulting in the prevention, restriction, or distortion of competition within the common market. It is not necessary to have actual prevention, restriction, or distortion of competition or a direct link between the concerned practices and consumer prices. An exchange of information between competitors is aimed with an anti-competitive object, since the exchange is capable of removing uncertainties concerning the intended conduct of the participating undertakings. Also, the Court of Justice confirmed that there must be subsequent conduct on the market by the participants and a relationship of effect and reason between the two. The Court of Justice held that there is a rebuttal inference that the parties concerned they have considered the information received from their rivals in their subsequent business operations. Furthermore, the Court of Justice held that a meeting on a single occasion between the competitors may in principle constitute a sufficient basis for the participating undertakings to concern their market conduct. But it is only possible depending on the nature of the market. The court stressed that what matters is not so much the number of the meetings or instances of information exchange between rivals, but rather whether the information exchange affected their behavior in the market or had the capacity to influence it. Therefore, a concerned practice may constitute an infringement under European law, antitrust law, even if it derives from a single meeting. And now to the conclusion. Thank you. So, as a result of this case, the Court of Justice decided that the behavior of the 5 Dutch mobile operators was a concerned practices and in breach of Article 101 TFEU. Thank you. Now I'm giving the word to Alexis.
From the cases, it has been indicated that small and large companies are going against the EU antitrust legislation. Especially, majority of the companies share sensitive information to dominate the market in the EU. Moreover, from the cases we can follow that there are many competitions between companies in the EU, leading them to go against some legislation so that they can rule the market.
Okay, now I would like to thank you all today. I'm going to end this meeting right now. So yes, thank you.